Hello, my name is Emily Hendrickson, and today we are going to be exploring the subjects of judicial independence and judicial decision-making. Now, before we dive in, one of the main topics of this discussion will center around the prevalence and complications concerning pornography regulation in our culture today. So first, we are going to talk about some judicial decision-making. So I've broken it down into three things. First, we're going to go over political alignments. Second are going to be influence of judicial philosophies. And then third are going to be some constitutional considerations. So are the Supreme Court justices required to politically align with their appointing president? Short answer is no. Due to the concept of judicial independence, judges and therefore Supreme Court justices operate free from outside influences such as governmental, political, or private interest groups. This means that judicial independence allows justices to decide cases solely on the facts of the law, ensuring justice is served and prioritizing constitutional principles are upheld. Being the highest judicial power in the U.S., the Supreme Court without a doubt holds an unparalleled influential position in American society. However, it is not free from influence. Although judicial independence frees the court from outside expectations and influences, it does not keep it hidden from internal influences. The inherent morals, beliefs, and values of a justice brings into the Supreme Court also influences their decision-making. Although judges are renowned for their impartiality, and equality is often regarded as an occupational requirement, the values and belief systems of Supreme Court justices and judges alike inevitably bleed into their decision-making. In the Supreme Court's case, they are an interdependent and conferral institution that hears cases and then voices their own opinions and reasonings on the subject. This means that each justice must hear the opinions, reasons, and arguments of the other justices. This conferral aspect of the court lets the justices hear arguments for the other side, meaning that their original opinion and beliefs could be challenged and possibly changed if the arguments are persuasive enough. Regardless of being appointed by a Republican or Democratic president, justices are not required to hold their appointing president's beliefs about policy or regulations. They do not have to please the president in order to keep their status as a Supreme Court justice. Once they are officially appointed and take office, Supreme Court justices serve for life and are removed either by death or personal retirement decisions, thus freeing them from political pressure to keep their job. Take the conflict over pornography regulation into consideration. The Supreme Court justices are required to legally research and answer the legal question concerning the availability of pornography. They are not required to provide their answer on the basis of the president's belief. That is the job of the Solicitor General. As I said in the previous slide, Supreme Court justices bring their own judicial philosophies and moral beliefs into the mix. There are numerous judicial philosophies, many of them unique to only the justice who holds them. However, for this discussion, we are going to focus on only two judicial philosophies, and that is going to be originalism and then living constitutionalism. Originalism is a theory of interpreting legal text holding that a text in law, especially the U.S. Constitution, should be interpreted as it was understood at the time of its adoption. The judicial philosophy of originalism is typically held by Supreme Court justices today. Proponents argue that the backwards-looking to history approach offers the only objective and neutral method for interpreting the Constitution. On the contrary, living constitutionalism is a theory that views the U.S. Constitution as a flexible, evolving document whose meaning changed with society's values, allowing the Supreme Court to interpret it in light of modern circumstances, not just the author's original intent. Historically, the Supreme Court has implemented both judicial philosophies into their decisions. For example, the Warren Court, which is from 1953 to 1969, is widely recognized as an era when the Supreme Court, headed by Chief Justice Earl Warren, treated the Constitution as a living document and championed the way for civil liberties by deciding historical cases concerning desegregation laws for public schools, which is evident in the Brown v. Board of Education case, voting reform, which is evident in the Baker v. Carr case, and then criminal justice rights, which is Miranda v. Arizona. So a question, do restrictions on pornography violate the First Amendment right to free speech? This is a question the Supreme Court must consider. First, they must consider the free speech clause of the First Amendment itself. To put it briefly, the freedom of speech is the constitutional right to express your opinions, ideas, and beliefs without government censorship or punishment. However, the amendment has exceptions for speech like incitement, defamation, threats, obscenity, and fraud. The court must consider whether or not pornography fits within any of these exceptions. There are many reasons for judicial apprehension to enforce restrictions on pornography. Often they emphasize the fact that adults have the right to access information, even sexual in nature, and cite the First Amendment's protection of sexually explicit material unless it crosses the high bar into obscenity. The justices may also show opposition based on the idea of censorship and show concern about the slippery slope that would arise from listing pornography as excluded from constitutional protection. So for this, let's go back to the president and his job of appointing Supreme Court justices. Typically, presidents select justices on the premise or belief that they will reliably and consistently hold a certain ideological, political, or constitutional viewpoints. However, like I said in previous slides, once appointed, justices are not bound by political or ideological pressures. They may stray from the expectations the president had when he first appointed them. This happens for several reasons. Lifetime tenure, as outlined in Article 3 of the Constitution, allows a judge to vote freely as they believe the law requires, without worry of repercussions. Similarly, the appointed justices are not required to uphold the president's political views or agendas. This is the essence of judicial independence. They decide cases free from political pressure, public opinion, or threats. Lastly, while judges may hold certain political alignments before appointment, these are often changed after appointment because they are now part of a group that collectively deliberates and airs their opinions and reasons. A justice's personal judicial philosophy is constantly evolving and changing along with society, and that is often reflected in their decision-making. So here are some historical examples of Supreme Court justices surprising their appointing presidents. So first, we have already introduced Chief Justice Earl Warren and the Warren Court's responsibility for deciding many legal cases that revolutionize civil liberties and societal norms. Clearly, this court exudes a liberal influence decision style, but ironically, when President Eisenhower appointed Earl Warren as a justice, he believed he had appointed a much more conservative seat to the bench. In later years, Eisenhower famously referred to his appointment of Chief Justice Earl Warren as the biggest mistake he ever made. President Richard Nixon was also surprised by a justice he appointed. While Justice Harry Blackmun abided by his perceived conservative views in the beginning of his service, he later shifted towards more liberal views, he authored the iconic Roe v. Wade case. And then this is my references. Thank you.